Can we
start now?
Grover, 1 second.
You will take it and
Let's start now. By 1 o'clock,
Okay.
we would have completed with Dr. Singhvi and Mr. Ramchandran's argument.
Now, Your Lordship's
I would
PDF
request my lord only 10 minutes of time, my lord, because this court, my lord, is not
tell us
usually it does not
I'll
restrict
tell you one
arguments
thing.
of counsels.
Look,
That
we are
is why.
also not ignorant. I've read Mata Nazbom extensively, and I still continue to read Mata. That's why after my day's deed is done in the court, this is what we sit down and read to get some sanity in our mind also at the end of the day.
I'm
For
only,
Mata Nazbom, do you have to keep on interrupting by the minute over here? I'm appearing for a gay activist. I want to show you Mata Nazbom. Of course, just give us a note. We'll read it.
My lords,
That's a matter of joy for us to read. It's a matter of joy
PDF
for us.
1180.
That's his birth
PDF
date, you know.
1180 minutes.
I mean,
My
it's
lords-
difficult to tell you. I was factoring that, okay, now summer vacation is going to be on this judgment. So we'll have enough time. There's not, the pressure of SLPs is not there. We'll sit down. So give us a note on Mata Nazbom.
the written submissions are already there. Only to indicate, only to
Point
take your
it out,
lordship
just
through
point
that.
it out.
Only I'm seeking some time. That is after
My
the
lords-
petitioners conclude, my lord. There won't be any repetition on from my side.
Somebody will
My
then say, I
lords-
want to now point out Rosalind Dixon. Why just
My
Mata
lords,
Nazbom?
I
Somebody
will
will say,
seek
I want to
indulgence of
point
my
out
lords
Bruce
only for 2
Ackerman.
minutes, my lords.
All right,
PDF
please, we'll love to
11.
hear it. I mean, I have this all of it threatening to fall on my head in the night. I've got such a pile of unread books.
PDF page 1180. Let me rush
Yeah.
through.
Chalo.
Would your lordships continue
PDF
on
page
Monday
1180.
also?
Yeah, we'll start on Monday.
My lord's prerogative, my lord, Monday is a working day, my lord. My lord,
There's also working. No?
no, my lord, it's admission day, my lord. There are several matters, my lord, which are already.
All right, we'll see, solicitor.
But let this start, my lord. On our side, your lordships may give us.
Solicitor, have you ever seen us being unreasonable in the court? Then, just we have to put a little pressure on everybody so that
Your lordship would not curtail us, but I'm confident about it.
Your Lordship has binary requests. One request for
Otherwise, we are
one
answerable
request
to our
for
own
one.
conscience, solicitor. We are
Your lordships
never will
would
until
be
we
guided.
feel that we have heard the matter fully.
Now, Malas, 1180 PDF. I'll just race through, Malas.
Just 1 second.
What do you want us to open, Doctor?
1180, Malas, PDF, that compilation of last evening.
143 that we were.
I'm grateful. 142 is over, 143 and 144 gets, Malas,
Volume.
Baroness Hale over.
Volume 2.
Not precedent. Volume 4. Foreign. Where are the volume 4 here? Foreign.
Yesterday evening, Baroness Hale, PDF 1180, para 143.
Volume one.
Volume compilation 4.
Volume 4, foreign judgments.
Yes, it's actually open.
It follows,
Just a moment, please.
143 you were reading.
got it.
correct.
That's where we stopped yesterday.
Correct, please. May I read?
Yes, please.
Yes.
It follows that a homosexual couple whose relationship is marriage-like in the same way that an unmarried heterosexual couple's is marriage-like are indeed an analogous situation. Any difference in treatment is based upon their sexual orientation. It requires an objective justification if it is to comply with Article 14. Whatever the scope for a discretionary area of judgment in these cases may be. This is very beautiful, but it can be transplanted subject to my Lord discretion to the Indian Supreme Court, to our Article 14. Whatever the scope for a discretionary area of judgment in these cases may be, there has to be a legitimate aim before a difference in treatment can be justified. But what could be the legitimate aim of singling out heterosexual couples for more favorable treatment than homosexual couples? It cannot be the protection of the traditional family. The traditional family is not protected by granting people, which is denied to people who cannot or will not become a traditional family. What is really meant by the protection of the traditional family is the encouragement of people to form traditional families and the discouragement of people from forming others. There are many reasons why it might be legitimate to encourage people to marry and to discourage them from living together without marrying. These reasons might have justified the act in stopping short at marriage. Once it went beyond marriage to unmarried relationships, the aim would have been to encouraging one sort of unmarried relationship and discouraging another. The Act does distinguish between unmarried but marriage-like relationships and more transient liaisons. It is easy to see how that might pursue a legitimate aim, and easier still to see how it might justify singling out the survivor for preferential succession rights. But as Lord Justice Buxton said, it is difficult to see how heterosexuals will be encouraged to form and maintain such marriage-like relationships by the knowledge that the equivalent benefit is being denied to homosexuals. The distinction between heterosexual and homosexual couples might be aimed at discouraging homosexual relationships generally, but that cannot now be regarded as a legitimate aim. It is inconsistent with the right to respect for private life according to everyone, including homosexuals, by Article 8 since Dudgeon's case in 1981. If it is not legitimate to discourage homosexual relationships, it cannot be legitimate to discourage stable, committed, marriage-like homosexual relationships of the sort which qualify the survivor to succeed to the home. Society wants its intimate relationships, particularly but not only if there are children involved, to be stable, responsible, and secure. It is the transient, irresponsible, and insecure relationships which cause us so much concern. Last para to be read. I have used the term marriage-like to describe the sort of relationship which meets the statutory test of living together as husband and wife. As husband and wife. Once upon a time, it might have been difficult to apply those words to a same-sex relationship because both in law and in reality, the roles of the husband and wife were so different and those differences were defined by their genders. That is no longer the case. The law now differentiates between husband and wife in only a very few and unimportant respects. Husband and wives decide for themselves who will go out to work and who will do the homework and childcare. Mostly each does some of each. The roles are interchangeable. There is thus no difficulty in applying the term marriage-like to same-sex relationships. With the greatest respect,
Dr.
I
Singhvi, this was a case where
Yes.
the Act squarely applied to unmarried relationships.
Yes.
And the principle was that if you're unmarried, if the Act applies to unmarried relationships between heterosexuals,
Yes.
there is no basis to exclude unmarried relationships among homosexuals.
It is the second last
Right.
formulation of
That's
the
what
Lordship
is really
sentence
said.
which I'm concerned about, that when you have a particular paradigm applying to a heterosexual group, your Lordship, Malas, absent something very special, will find it discriminatory not
That's
to apply
why
it
the
to
judge
another.
uses, Baroness Hale uses the expression marriage-like relationships.
Yes.
So these are not marital relationships, marriage-like relationships of heterosexual couples who are in a stable relationship, but who are not married. They said that therefore, if you are extending protection to heterosexual couples who are in a marriage-like relationship and therefore not married, there's no basis to deny it to homosexual couples who have a marriage-like relationship but who are not married.
I'm grateful, Malas, that's one. But Malas, the language of the paras I've read yesterday and today
Maybe
are
also
very,
capable of
Malas,
extension, you're right.
and your Lordship is not bound by these judgments. Your Lordship will find persuasive value to the extent your Lordship finds. Now I turn to that article, Malas, which according to me is one of the most well-written articles on interpretation. On reading down, reading up, what your Lordship
Which is that article now?
treaty compliant, or in our case, constitution compliant reading. Constitution compliant reading. Kindly hand over. It's better to use the hard copy. I'll read only 3 sections, a few pages of it. Kindly hand over.
Oh, okay. Sorry, I was just. Thanks.
We also emailed you, but this is better and quicker. The Lordship may mark this.
The judgment is done.
That is done. That is over. Now, kindly come to the first page. What is the year of this? What is the year of this publication? Don't do multiple things. Focus. Year. Just come to the first para. You will ignore. I mean, it's about UK and New Zealand. Second para on the first page. On the first, I'll be making mark only some portions. It's rather well put, and it is triggered by. That's the reason I'm citing it. The key question for the courts in applying such directions is how to determine when it is or it is not possible to ascribe a rights-consistent meaning to the legislation. Although a definitive answer to that question has proved unsurprisingly elusive, a shared assumption to date has been that the line that is being drawn, this is the point for this, line that is being drawn between interpretation on the one hand and legislation on the other. The task assumed by the courts is to search for an interpretation of the relevant statutory provision that would bring it into conformity with human rights standards. Now come to page 2, Malas. Beyond the margins of interpretation, however, lies the constitutionally impermissible territory of judicial legislation. And that's your Lordship's equation. The next parameters, given this characterization as essentially interpretive, it is perhaps unsurprising that I'll skip the New Zealand specific para, come to the third para. In the United Kingdom, however, and this is important, a new model now seems to be emerging. In a series of cases, culminating in the decision of the House of Lords in Ghedan, I just read it, the United Kingdom courts have cast doubt over the centrality of statutory language to the determination of whether a rights-compatible reading of legislation is possible in the right of the Human Rights Treaty. The text is not, the law lords have said, determinative. The text is not determinative. Rather, the courts will be constrained only, mark the word only by the underlying thrust of the legislation A and the limits of their institutional capacity. Now, the counter question, the devil's question, is posed in the next paragraph. This paper discusses Ghedan and its implication. It suggests that the remarkable aspect of Ghedan is that it simultaneously divorces the process of statutory interpretation under HRA from the twin anchors of parliamentary intention and statutory text. This I'm relying upon heavily, this first sentence. The second part, in that light, it is suggested that the dichotomy between interpretation and judicial legislation is at the very least under pressure, and the courts are in fact appropriating to themselves a significant, if nevertheless a subsidiary slice of legislative power. Now come to page 8. This is page 8. So, ready to write it down. Page 8. Of the four law lords in the majority,
Yes.
of the four, page 8, 8. Roman, big Roman 2. Of the four law lords in the majority, the names are given. All but the last delivered a separate opinion on the correct methodology under 3.1. There was, however, substantial agreement on these essential principles. Then the key issue, separating the sheep from the goats. Their lordships identified the key issue under 3.1 as being how to determine the limits of what is possible. The scheme of 3 and 4 of the treaty envisages that there is a Rubicon which the courts may not cross. What is not, however, spelled out is the test to be applied in separating the sheep from the goats. Parliamentary intention is not the touchstone. This is another red herring which your lordship may have to deal with in the present case. In investigating the line between the possible and the impossible, Lord Nicholas and Lord Stein held that the courts were not constrained by the intention of the Parliament that enacted the legislation. Very, very important. Lord Nichols distinguished the required approach in this respect with the orthodox approach to standard statutory interpretation, which involves seeking the intention reasonably to be attributed to Parliament in using the language in question. In contrast, Section 3 may require a departure from that parliamentary intention. The key question being how far and in what circumstances. This is because there is another and a countervailing parliamentary intention which needs to be given full weight. Namely, the intention reasonably to be attributed to Parliament in enacting 3. So it's an objective test being brought in. Objective. Now, nor is the statute. The second thing which is not determinative is statutory text. And it is quite interesting and astonishing, though now in a constitutional context, American English courts are saying this. When we were brought up, it would be sacrilege to suggest this to an English court. Remarkably, their lordships held that the language of the statutory provision at issue is not the touchstone in deciding which it is not possible under 3.1. This holding had a number of dimensions. Further, their lordships expressed concern about excessive concentration in a literal or technical way on the linguistic features of the statute. Rather, Section 3 requires a broad approach, concentrating amongst other things in a purposive way on the importance of the fundamental right involved. So intention one way, statutory text one way. Now we've got a third test, importance of fundamental right involved. Secondly, their lordships stressed that the proposition that ambiguity in the statutory language is not a prerequisite to the operation of 3.1. Ambiguity is not your lordship's poll star. Thirdly, 3.1 might thus have a role even if the statutory language is not capable of bearing two meanings. Lord Nichols says, once it is accepted that 3 may require legislation to bear a meaning which departs from the unambiguous meaning the legislation would otherwise bear, it becomes impossible to suppose that Parliament intended that the operation of 3 should depend critically upon the particular form of words adopted by the parliamentary draftsman in the statutory provision under consideration. That would make the application of 3 something of a semantic lottery. From this, the conclusion which seems inescapable is that the mere fact that the language under consideration is inconsistent with a convention-compliant meaning does not of itself make a convention-compliant interpretation under 3 possible. So this is impossible, I'm sorry, impossible. So your lordship's ultimate guide star is intention, no. Text, no. Parliamentary, well as overall purposive theological, no. But the ability to achieve a convention-compliant result. A convention-compliant result. Next page, Wallace, at page 10, I'll just read the quotation. Fourthly, their lordships considered that 3(1) empowers the court, if necessary, to change the meaning of the legislation. This is actually the heart, the legal heart of this case is this, Wallace, interpretation, how to look at these sections. 3 enables language to be interpreted restrictively or expansively, but a 3 goes further than this. It is also apt to require a court to read in words which change the meaning of the enacted legislation so as to make it convention compliant. It is apt to require the courts to read in words which change the meaning of this enacted legislation so as to make it convention compliant. In other words, the intention of Parliament in enacting 3 was that to an extent bounded only by what is possible, a court can modify the meaning and hence the effect of both primary and secondary legislation. Their lordship's view is not the touchstone in determining whether a convention-compliant reading of legislation is possible, begs the question. If not the words, then what? How then is one to sort the sheep from the goats? Their lordships identified 2 overlapping limits. So now he's answering the question, how do you separate the sheep and the goats? What is possible under 3(1)? This is the first test, fellows. General thrust of the legislation. Second is court's institutional capacity, which is defined later on, coming out later. As to the first, their lordships held, 3(1) does not authorize the courts to adopt a meaning that is inconsistent with what they variously described as fundamental feature of legislation, underlying thrust of legislation, grain of legislation. Each of the footnotes gives a lordship the para. A cardinal principle of legislation, the very core and essence, the pith and substance of the measure. Well, to take a 5-second aside, it is a kind of a basic features intra-legislation. Basic structure doctrine, intra-legislation.
Right.
These are very interesting developments. The lordship is...
The tenor and the provision
Tenor.
of the law.
Exactly.
That internal, does it make internal
Intra-legis.
sense?
It has to be intra.
Therefore, you can't confine it to...
Correct, correct.
Wow.
This notion that the courts cannot turn, page 11, 11, top. This notion that the courts cannot turn the scheme of the legislation inside out overlaps with the second point, which is that the courts cannot make decisions for which they are not institutionally equipped. Now, what is the meaning of this? Some cases that lordships held call out for legislative deliberation. So if it's a case where a lordship finds the whole script has to be written, it has to go to the legislature. This might be the case, for example, if the exercise of making the legislation convention compliant would involve the substitution of a detailed statutory scheme. It's a very fair test, well, it's a very fair test. Or if a policy choice needs to be made between different methods for achieving convention compliance, or if the decision would have far-reaching practical repercussions, the courts are not well equipped to evaluate. This has to go case by case, well, to your lordship's ultimate decision. Now come to 13, page 13, 1-3. In Ghaidan, however, lower part, second half of the page. In Ghaidan, however, the House of Lords rejects both a focus on text and a
पवित्र
focus on
अल-अक्सा
purpose.
मस्जिद में पहुंचे जिसमें बच्चे और महिलाएं भी शामिल नजर आए.
Does it have page 13 lower part? I'm just doing a little bit of speed reading, your lordship's permission. Now, your lordship of teleological purpose, Bennion. So even that is out. Both a focus on text and a focus on purpose. This creates something of a puzzle as to what their lordships might mean when they say that the interpretive possibilities created by 3 are limited by the underlying thrust, 1, of the legislation. Considered in isolation, that proposition might sound a restatement of the modern purposive approach to statutory interpretation. The purposive approach has, however, been explicitly rejected by their lordships. The intention of Parliament in enacting the relevant legislation must, they said, give way to the intention of Parliament in enacting. That the underlying thrust approach is not consonant with the purposive approach is manifestly evident from their lordships' analysis of the statutory scheme, page 14, top colors, at issue in Ghaidan itself. Lord Nichols postulated that the social policy underlying the extension of security of tenure in 1988 to survivors of de facto opposite-sex relationships was equally applicable to survivors of de facto same-sex relationships. On the basis of that essentially normative conclusion, he held that the underlying thrust, this is the test for us, the underlying thrust of the Rent Act of 77 did not preclude a convention compliant interpretation.
So then
The underlying
two parts. One is yes, this is how you make it consistent with the convention. The second is they abandon the purposive construction method.
and the textual and the intention based. Now, if your lordships were to find
Was it? Diametrically.
if there's a prohibition,
I'm just
I would
asking.
say, in fairness, the answer would be no.
Then
If the language is diametrically opposite.
interpret it to
No,
choices of the
lordship
court.
is, when your lordship puts that question, I am answering it saying that diametrically opposite must mean prohibition.
The prohibition, that could be.
Prohibition.
We are looking.
Answer has to be
let
no.
us, let
I'm
us-
not here, Malas, to suggest your lordship that your lordship has a prohibition and your lordship is then overriding it on the basis of interpretation. Then your lordship may be able to override it for Malas some second argument. It's not the only answer. Second answer is
But if
your
that
lordship
provision,
as not constitutionally compliant. Malas,
when-
there are two ways of looking at this. One is that we challenge it on the ground of unconstitutionality, as we are doing the notice and objection provision to which I have just returned. Your lordship will then apply that test. The first test my Lord Justice Narasimha is asking me is intra-legislation. To that, the answer would be if there is a prohibition, and I still ask you to only interpret. Your lordship may have
How can
difficulty.
we confine to that concept that if there is a prohibition, then only we say that it should go back to the legislative drawing board? Because,
No, if it is not constitutionally compliant on the larger challenge, no, your lordship can strike it down.
because, let me complete. We are looking, focusing our gaze on the only provision. In Ghaidan, it was possible. Ghaidan, the question was simple. And also Ghaidan was not essentially concerned with matrimony. Essentially, it was concerned with protecting tenants and whatever was the consequence if one of them who was living in a relationship died. So therefore, it was possible to not even go into the internal mechanics of the concerned enactment. Here, perforce, whether you like it or not, we will have to insert ourselves into the mechanics of.
Therefore,
Yeah.
Malas, therefore, two things. Ghaidan, the underlying, although the issue was Rent Act, the underlying thrust was found by all 5 judges to mean that you cannot discriminate between heterosexual couples
Given.
versus homosexual couples in the interpretation of that act. Number 2, the question would be if your lordship found that SMA, the underlying thrust, is not this, or the SMA precludes that underlying thrust, then your lordship would go one way. If your lordship, however, were to find that the underlying thrust of SMA does not exclude, and that's the heart of the answer to my lord's query,
Preclude as-
does not preclude or exclude a same-sex couple, that's follows, therefore, that choice ultimately
See,
follows the.
If presented the way Ghaidan is presented, we have no difficulty. But if you take the steps in Ghaidan, which is the internal sense of the enactment, then we will necessarily have to go into
The
other
two
provisions.
different acts, lordship naturally, this is Ghaidan is something
Then-
else, this is something else.
Then
I'm only on the
the
approach.
route
to
which
interpret-
we may have to take is something else.
Well, I'm only giving your lordships a approach to
Yes, you are
interpretation,
right.
which should comment your
It's
lordship,
quite a
obviously in a different context.
It's a
Obviously
very novel approach.
novel approach and a
But
different
having
context.
said that, here you're really leading us on the path of statutory interpretation.
That's true.
Statutory interpretation, not based on text, not based on intention,
Go beyond.
not based on original intention, not based on purposive teleological
So you're
interpretation.
really asking us to read into the statute the expression spouses for really man and woman.
So
And
does the
therefore-
underlying thrust of SMA exclude your lordship's reading or insertion or understanding of that construct. Is the
Because
case?
your principal premise is that when the legislation was enacted in 1954,
Yes.
the object of the legislation was to provide a form of matrimony for people who are not falling back on their personal law of marriage,
Absolutely, absolutely.
right? And not,
Special categories.
you are giving Parliament was intending to provide an avenue to people beyond
Beyond.
your religious, the religious governance of marriage, so to speak.
There was also an aspect of endogamy.
Yeah.
There was
Yes,
an aspect of endogamy
yes,
which
yes.
we cannot ignore.
Yes, yes, yes.
So
yes.
it was an all-enfolding kind of a legislation.
And it cut across so many spectrum because it was intended to
And
be a very
therefore,
special
after
category.
1954, in the last 69 years, our law has really evolved to recognize the fact when you decriminalize homosexuality, you also realize, well, these are not just one-off relationships. This also comprehends the stable relationship.
Because you go back and
Therefore,
say, yeah.
by decriminalizing homosexuality, we have not just recognized fleeting relationships between consenting adults of the same gender, right? We have also recognized implicitly, therefore, the fact that people who are of the same sex would be in stable relationships. Now, if the object of the law in 1954 was to bring in its fold people who would be governed by a matrimonial relationship apart from their personal law, then surely that law is capable of being broadly read according to you, so as to take into account more stable relationships.
Let me put it bluntly.
The same sex as well.
Let me put it bluntly. When you enacted the law, you did not, in the debate in Parliament, in the writing of the draftsman, when I get up and speak on it, may not have got homosexuals in mind. You may not have considered them.
Way of
That
looking
makes
at
no
it.
difference.
You may
Another
not.
way which you are perhaps propounding is this provided a framework, but that framework is of the concept of marriage. The
Exactly.
concept of marriage transcends
As it
contemporary understanding to
It's an evolving,
comprehend-
dynamic concept.
to
Absolutely.
comprehend an evolving idea of
Dynamic,
marriage.
very dynamic concept.
So used in a constitutional sense, it only provides a framework.
Framework.
And that framework is broad enough to, assimilate later developments.
I
So it
don't want to.
transcends the existing.
I don't want to sound well. That is really well put with respect. The provision of a framework which departed from the existing framework already, because it took care of personal laws. Now, in that framework, are you cast in stone, or are you in an evolving dynamic picture? And can the underlying thrust and your lordship's institutional capacity sustain it? This is the summary of the whole Ghaidan principle applied to SMA.
And from the perspective of institutional capacity, we have to ask ourselves whether we would be doing something which would be fundamentally contrary to the scheme of the statute.
You also have to make a new
Or
statutory
with
scheme.
yeah, exactly. Would the
New
court be
statutory
rewriting the entirety of the statute? Would the court really be making policy choices which is for the legislature to make?
Lordship.
So long as we don't straddle that line which divides policy from the judicial process, you're still within the fold of it.
I'm very grateful, which is why they have put this second test. The
But
first test
equally,
was
I
enough.
think the impact of
Put the
Ghaidan
line.
is to liberate the court
Yes.
from the very, very traditional approach
Yes.
of looking at everything as a matter of statutory interpretation. Therefore, purposive interpretation also falls back on interpretation of that statute and the language of that statute.
That is important, Malas. That teleological and purposive also, which is supposed to be in
I'll
advance,
play again-
falls back.
I'll play a little bit of a spoiler. Ghaidan provided the framework for the introduction of a law in 2004, which assimilated all these developments, which led to the blessing of statutory recognition of these kind of partnerships. And then it took another 10 years for these to be recognized as marriages. So that too is an aspect which we will have to keep somewhere in mind.
Absolutely, Malas. Your Lordship, that's the difference. It's a holistic thing your Lordship keeps in mind. Ultimately, the feel of the case is only your Lordship will. That is, nobody can be identical. Nobody is saying
Because
it.
I'm sure if you go to Ghaidan and if you follow it up, there could be other cases which you have followed.
Now,
that
so I've now Malas, time, given my
Dr.
time.
Sigbee,
I've
we
done
have,
this.
Dr. Sigbee, I think, I mean, looking at India constitutionally and socially as well,
Yes.
we have already reached the intermediate stage, right? The intermediate stage postulates that by decriminalizing homosexuality, your very act of decriminalizing homosexuality does contemplate that therefore people who belong to the same sex would be in stable marriage-like relationships.
Marriage like is the operative word.
Right, marriage-like relationships.
Live together.
Because the moment we have said that it's no longer an offense under section 377, therefore we necessarily contemplate that you could have a stable marriage-like relationship between two persons who do not treat these as chance encounters, but as something more than that, not just a physical relationship, but something more of a stable emotional relationship, right?
Societal.
Which now is an incident of our constitutional interpretation. Once we have made that, we have crossed that bridge, then the next question is as to whether our statute can therefore recognize not just marriage-like relationships, but relationships in the relationship
On the
of
contrary,
marriage.
Mills, I started by saying it's a logical move in the same direction. It is, in fact, little done, vast undone. Your Lordship is now getting to cover that territory because to merely decriminalize is one category. Otherwise, it does, in an actual daily sense, remain a shell.
Requires us to,
Hollow shell.
requires us to redefine perhaps the evolving notion of marriage, because